Hear ye, hear ye, hear ye. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court draw near, give attention, and you shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Welcome to today's session of the Supreme Court of Arkansas. We're conducting our oral argument today virtually by Zoom because of the ice storm. And I want to thank our clerk, Kyle Burton, and his staff for getting things arranged to conduct it in this manner, especially on such short notice. And let me ask the clerk now to read the submissions.
There are 5 appeals being submitted to the court for decision today, the first of which will be our oral argument. It is from Pulaski County Circuit Court, CV-22-204, Chris Corbitt versus Pulaski County and others. We also have CR-22-219, State of Arkansas v. Tyler Pate from Faulkner Circuit, CV-22-281, A1 Recovery, Towing and Recovery, Inc. versus Larry Walther, Secretary of the Arkansas Department of Finance and Administration from Pulaski Circuit, CV-22-283, CNARC Investment Group, LLC versus Larry Walther, Secretary of the Arkansas Department of Finance and Administration from Pulaski Circuit, and CV-22-326, Gerber Products Company versus Mitchell, Williams, Seelig, Gates, and Woodyard, PLLC, and others, which was certified from the United States District Court for the Eastern District of Arkansas. In addition to these 5 appeals, there are 12 various other motions and petitions submitted for the court to consider today. Information about these submissions is available on the court's website.
Okay, thank you, Kyle. Our case today for oral argument is Corbitt versus Pulaski County and others. And the court will now recognize counsel for the appellate, Mr. Steinbuck.
Thank you, Your Honor. May it please the court. My name, as you know, is Robert Steinbuck. I appear here as an attorney, but I would like to welcome my students from the Bowen Law School, many of who are watching today. Let's get started with the issues. First, what's on appeal? Appellees argue that only the writ of mandamus is on appeal. If you look at the notice of appeal, however, that's not correct. It says this appeal involves a circuit court order denying plaintiffs' motions for A, declaratory judgment, B, injunctive relief, and finally, C, writ of mandamus. And it says Chris Corbitt appeals the circuit court order denying his motions. Now, it is true that in the title section of one part of the brief, we were incomplete, and we sought to amend that prior to appellees filing their brief.
Counselor,
Yes.
Counselor, isn't that an implicit admission that you got it wrong?
Well, no, indeed, we sought to amend, and I'm confused, frankly, why the court didn't follow its own rule, 4.4, that says I'm entitled to amend, and it says at the court's discretion, the court will routinely grant such a motion. Remember, this motion was unopposed. So the court decided to deny this motion with no opposition whatsoever before appellee even submitted their brief. This case is about gun rights, and the denial in this case will be about gun rights, whatever the process that gets us there. But that denial of my ability to amend my brief, even though all of the contents of the brief, all of them speak to all the motions, the only thing that was an error, and we asked to correct it. I mean, let's be frank, people are allowed to make errors, and we're allowed to ask for an option to correct those errors unopposed. That doesn't change. Every word in that brief deals with all of the substantive issues, not just the writ of mandamus. We go on. I think there was actually a little bit of talking past each other for me and Frank, my good friend Frank, appellee's counsel, and that is that this case only deals with courthouse, not courtroom. So we've submitted a case from Mississippi that says gun owners are entitled to bring guns into a courthouse in their statute, much like our statute. And the Supreme Court of Mississippi said exactly that. Appellees cite a case from New Hampshire that says, guns aren't allowed in the courtroom. This case isn't about courtroom. I suspect we'll have a case about courtroom, but this is not the one. My client would never made it past the courthouse doors. So the dispute here is only about.
Counselor,
Yes,
let's back up procedurally.
Yes, ma'am.
Why did you originally file a petition for declaratory judgment rather than for a writ of mandamus?
No, we filed both. We filed a declaratory judgment and a writ of mandamus.
But initially, it was a declaratory judgment.
Oh, in terms of the timing?
Yes.
I don't know why we did one versus the other first.
In doing so, what were you seeking by asking for a declaratory judgment?
We want the court to say that my client and similarly situated individuals, incidentally, have the right to enter a courthouse with a gun because he's an officer of the court.
To make a declaration of his right to carry the gun.
Yes, ma'am.
In that circumstance.
Yes, ma'am. And the court ruled on that.
Yes. So now tell me what the components of a successful writ of mandamus would be. What do you need to show the court?
Well, we have to show a clear right that has not been fulfilled.
Okay.
Right.
Well, if you have asked for a declaratory judgment of a right, then how is that also a clear right?
Well, we think the right's clear. The court can issue it.
Why did you ask for a declaratory judgment on that rather than just a writ of mandamus?
Well, I don't think you can't ask for a declaratory judgment if you have a clear right. What you can't do is ask for a writ of mandamus if you don't have a clear right. So we think it's a clear right. We're able to ask for
have
both.
a clear right, then why do you need to ask for a declaratory judgment? Why not just originally file for a writ of mandamus?
Well, I would perhaps put it differently. I think a fair question for you to ask me would be, well, if it's a clear right, just go for the declaratory judgment and have the trial court issue it instead of using an extraordinary writ.
Well, I'll frame the question how I choose to.
Fair enough. But my point is the same. My response is the same, meaning the substance to prove a declaratory judgment, to grant a declaratory judgment with a clear right is the same substance that is needed to bring a writ of mandamus. I brought them both. I do belt and suspenders. If you think one's no good, but I brought the other, I should be fine, right? So I'm not saying that you should grant both. Just grant me one. So, the next issue is standing. Does the appellee have standing on the separation of powers argument here?
Mr. Steinbeck,
Yes.
let me interrupt for a moment and go
Of
back
course.
to the question Justice Hudson asked before we get into standing. I mean, haven't we said that a writ of mandamus will not lie if there's another adequate remedy available? And if the declaratory judgment had been successful, then that would be an alternate remedy that would prevent the mandamus from issuing.
That's correct. That's correct. I brought both. If the court would say, the trial court could have easily said, you can't get a writ of mandamus, but you can get a declaratory judgment. So I brought them both. But the court said I get neither, and I've appealed both. In fact, all three, right? So, and that was the point about amending the brief and the notice of appeal. That's where the substance is listed. Regarding standing of separation of powers, there is no court order. So appellees point to writings of the county judge. But remember, the notion of separation of powers are equal branches. So the judicial branch of the state, you all, is of equal standing to the legislature. The judicial branch, if it is, and we'll get into that, of the county is lower. So there can be no argument there. Moreover, the county judge is not a judge. He's an executive. It's an old title, and that's fine, but it's an executive. The appellees cite two cases. The first case, they don't tell us, but they cite the dissent. I'm not going to argue that they cited the dissent because the dissent supports my case. The dissent literally says that the meeting of the county judge is, quote, this meeting is not a judicial proceeding. So that's my point, that the county judge is an executive. And the second case deals with judicial immunity, and the court said that the county judge got quasi-judicial immunity. You know who gets quasi-judicial immunity? Administrative law judges. You know what administrative law judges are? Not part of the judiciary. They're part of the executive. So There is no judicial opinion. Then the appellees say, well, they consulted with certain people in the courts. Oh, it's true. There's no big all caps that says order. We're not looking for all caps that says order, but we're looking for something that substantively is a judicial order, and the security plans are not judicial orders. Moreover, if that's the judicial order that they're relying on, where in the security plans does it talk about off-duty law enforcement? Security plans aren't built around off-duty law enforcement, but the law talks about off-duty law enforcement quite a bit, in fact. So it can't be that the security plan is the authorization or the standing or gives rise to the standing for the claim of separation of powers. Let's get into that statute. See if we can see that. Sorry, little bit of, gotta get the lighting here. I hope you can see that okay. The lighting's not great. Bear with me, I apologize. We don't have the share screen option for technical reasons, so I'm providing you here the statute, right? And so this is the current statute. And you see, it says law enforcement officer, either on duty or off duty, then officer of the court, then bailiff, and then other person authorized by the court. And so the question is, what do each of these terms mean? Now, remember, we interpret gun rights consistent with the Arkansas Constitution and the U.S. Constitution, and those afford citizens gun rights. It says law enforcement either on duty or off duty.
Counsel,
Counsel,
I'm going to interrupt you. So
Yes.
since we're going into the statute, so
Yes.
Your argument is officer of the court includes attorneys, correct?
Yes, ma'am.
So that would include judges. Would you agree, since all judges are attorneys?
To some extent, meaning that the statutes tend to differentiate between attorneys and judges. So judges are a subcategory of attorneys, much like, by the way, I'll get to it in a moment. It says bailiff.
No, well, when you say, all judges are attorneys. We have to have a bar license to practice law. And we have to have a license to run and hold office.
Yes, ma'am.
So we're all officers of the court.
You are officer of the court, but you're a subcategory of officer of the court, meaning judges. So
okay. So then I guess my question is, if we read officers of the court as including attorneys and the subcategory judges, then what is the purpose of subsection E that says that a justice of the Supreme Court or a judge of the Court of Appeals can carry them into the Arkansas Justice Building? Because under your reading, officers of the court, then that renders subsection E superfluous, which we will not do.
Of course, this section was amended after that section that you refer to. So this section created these rights, and I'll show you the old statute where these rights didn't exist when the section that refers to the justices had already been in place. So we have a new section that didn't alter the section about justices. And you'll see throughout the code that there are various provisions that give special privilege to justices. So that special privilege, or judges, I should say, that special privilege that was given to judges remained in the statute. And then an additional privilege was given to officers of the court. That's how we wind up with the statute.
So why wouldn't they have just said attorneys if they didn't include officers of the court to mean judges as well?
Oh, we can always come up with a better way to write a statute. That's not a basis to say that this language doesn't mean what the plain language means. Could they? I haven't read a statute that I couldn't write better second time around. So yes, that would also work. But one of the reasons I will tell you is that officer of the court was in the statute before with a different meaning, with a more or that's perhaps an overstatement, but a more narrow role than is now the case. And you'll see what I mean by that. Let me turn to that, in fact, right now. Sorry. So if you look, the old statute said that a law enforcement officer, this is new language, so we're going to skip that, officer of the court or bailiff acting in the line of duty. Now, this phrase, acting in the line of duty, here, I'll show it to you unredlined. I'll show you the old statute, unredlined. Any person other than law enforcement officer, officer of the court, or bailiff acting in the line of duty. At that point, this is the argument, frankly, that the appellees are currently making. They're making the argument that all of these are law enforcement. Well, when you talk about acting in the line of duty, that makes sense. It sounds like they're all law enforcement. But the legislature realized they made a mistake, and they then amended the statute so that it now reads that only law enforcement officers are modified by on duty or off duty. They amended and expanded, right? It was just on duty, and now it's on duty and off duty. And then officer of court and bailiff don't have that amendment because they're not law enforcement. You might be thinking, aren't bailiffs law enforcement? It depends on the jurisdiction, the county. That's determined by state statute, and counties vary on that. And so to ensure that bailiffs can come in for those who are not law enforcement, we needed to have a separate category. So the legislature fixed the broken language by moving acting in the line of duty up here and then including off duty as well. So,
Counsel,
yes,
with
ma'am.
regard to the, we're not talking about off-duty and on-duty law enforcement. With regards to officers of the court, do we have anything that tells what the intent of that language was in 2017?
Well, we have to read it from the context, and let's take a look at another statute. Here's Arkansas Code 1613-1413. It's a similar issue. It deals with bailiffs, and it says bailiffs provide security for individuals involved in court proceedings, parties, right? Officers of the court, lawyers, and judges. There's your distinction, incidentally, Your Honor, when it comes to distinguishing officers of the court and judges. The courts tend to not use officer of the court to cover judges. As I said, it's a subcategory. They're treated specially. And for that reason, the legislature tends to use separate language for both. May I continue? I gather I can. Tell me if I can't. The broader question, why have three categories here and then say other persons authorized if appellee's argument that it's only people who are authorized are allowed in? Why wouldn't you just write, speaking of, why wouldn't you write it differently? Why wouldn't you just say anybody that the court authorizes? Why? Because law enforcement officers, officers of the court, and bailiffs don't need authorization. Indeed, if you look at in Lexis, this statute, ACA, let's just call it 122 for the ending part. At the end, and Lexis, as you know, is the official reporter for the court, for the legislature. If you look in the end, it has notes, and it's called the ACRC notes. And they say when this law was enacted in 2019, they put in language that doesn't get codified, and it says, policy required, a state institution shall develop a policy consistent with this act concerning lawful open or concealed carry of a handgun by an off-duty law enforcement officer at a state institution affected by this act. Now, if this was at the discretion of judges or the court, the judiciary, how could the legislature, I'm not sure if you can't see it. How could the legislature mandate that? They couldn't mandate that. Indeed, appellees argue throughout their brief, every time the legislature gives authority to the judiciary to do something, they turn over some authority, the appellees argue, oh, well, you see, that's a recognition of an existing right from separation of powers. No, it's not. You don't write a statute, for example, that says, hey, everybody has a First Amendment right. You know where you have a First Amendment right? In the First Amendment. You know where you have separation of powers? in separation of powers. When the legislature tells the judiciary that it can do something, it's telling the judiciary it can do something because the legislature retains that right until it gives it over to the judiciary. The same way the legislature created cities. Cities do all sorts of stuff now. Legislature brought cities into being, they can take them out of being. These are functions of legislative action. Let me just see.
Counsel, I'm going to interrupt you.
Yes, ma'am.
I think there's a problem with our clock. It ran down to 0 and now it's actually
It's because,
increasing.
yeah, because I have 15 minutes.
I'm gonna ask if our clerk knows the timing.
Judge, I can tell you, I've got 15 minutes, but I reserved 5 and I've now used 2.5 of my
That's correct.
rebuttal
He's
time.
used 2.5 minutes of his 5-minute rebuttal.
Okay, if I don't know if you want to stop and save
No,
your rebuttal
I'll say
time.
two more. I'll say 2 more things, and then whatever's left is left, as is the case with life in general, right?
Mr. Steinbuck, let me ask you real quick.
sir.
So are
Yes, sir.
we talking about guns in the courthouse and not the courtroom?
Yes, sir. That's exactly correct.
Okay.
That's exactly. 2 more quick things. Appellees argue, wait, the statute says that off-duty law enforcement have to have ID, but lawyers don't. Well, first of all, we have ID. Here's my ID. But second of all, that makes sense because this court is the one that says, I'm an attorney. I'm an officer of the court. So this court can keep a roster in the courthouse. This court doesn't know who law enforcement are. They aren't certified by this court. So that's a rational basis for that distinction. And finally, off-duty law enforcement are not allowed to carry if they are parties to a case, but lawyers are. The officers of the court are. Again, that's a rational decision. That's a policy decision made by the legislature, not by the court, in which they believe that, by the way, the greater number, law enforcement is more than attorneys, a greater number of law enforcement when off duty shouldn't carry guns, and they don't have this notion regarding officers of the court. With that, I will complete my argument.
Counselor, I recognize that at the beginning of your argument, you recognized your students, and I'm certain the court is delighted to have them here. I want to make sure that you understand that you are not in your classroom today. You are appearing before the Arkansas Supreme Court, and you and your client are not wearing coats.
Yes, ma'am. I recognize that.
You have a coat handy.
I have one. I have one in the other room. The reason I'm not wearing.
We will wait
Okay.
for you to be dressed appropriately. Please
Okay.
find your coat.
Hold on. Your Honor, just for the record, I didn't wear the jacket because I can't manipulate the chart that I was using with the jacket on well. I kept knocking it over. In any event,
To that point.
Yes.
Generally, counsel asks for permission before they bring exhibits, and you did not do that to my knowledge.
no, I did not. Not of the court. No.
Again, you're using this also as an instruction for students, and I appreciate that. But for that reason, I think we need to take a highlighter to a couple of large missteps you have taken procedurally with this court this morning.
Sure thing.
Thank you.
At this time, the court will recognize the counsel for the appellees.
There we are. May it please the court. I'm Frank Laporte Jenner, speaking on behalf of Pulaski County, specifically Pulaski County Jail, Barry Hyde in his official capacity, and Sheriff Higgins in his official capacity. We are here today to talk about the rules that we apply when interpreting the law. The parties, in trying to interpret this statute, have applied a variety of different legal maxims and theories to come to the correct interpretation And unfortunately, the statute has not easily lent itself to a perfect interpretation. What will guide this court, however, to the correct interpretation is what guides the law itself, the Constitution. This statute, like every statute, needs to be interpreted in a way in which it does not conflict with the Arkansas Constitution. So though this statute does not lend itself to an easy interpretation, we still need to seek a constitutional interpretation, and that is the interpretation that we are presenting here today. So looking at the statute itself, now, it seems like this is a new development that we are talking about courthouses and not courtrooms. Throughout the entire proceedings of this case, it was my understanding that the appellant was seeking to enter a courtroom with a handgun, and that was the language in the statute itself that says, just looking at the statute itself, it says, a law enforcement officer, either on duty or off duty, officer of the court, bailiff, or other person authorized by the court is permitted to possess a handgun in the courtroom of any court or courthouse of this state. So it's been my understanding that that the appellant was seeking to bring a handgun into a courtroom pursuant to this statute. As far as courthouses go, this provision in the statute that we have discussed so thoroughly doesn't speak to courthouses. It simply speaks to courtrooms. I think what would cover courthouses would just be under the original provision of Section 122, where it just states that you are not allowed to bring a handgun into a public space. This provision is simply just speaking to courtrooms themselves, and that has been the discussion from the beginning. So this discussion about courthouses is relatively new to me, so I apologize. I feel like we've kind of changed what we were looking at the last minute. But going to what has been argued throughout the case as far as the appellant's authority to bring a firearm into a courtroom, as he has pointed to this statute, we have pointed out in this statute, so his interpretation is that these four categories that are discussed in that provision, paragraph B, officers, either on duty or off duty, officers of the court, bailiffs, or persons, these are four distinct categories. And so under the appellant's interpretation, only that last category is modified by that phrase, permitted or authorized by the court. We have looked at this and said that every one of those categories is modified by the phrase authorized by the court, because that is what prevents a conflict with the Arkansas Constitution. As we know, the Arkansas follows a strict separation of powers doctrine. So the judicial branch is the branch of government that has control over the courtrooms of this state. And so that is further supported by Amendment 80 to the Constitution, which says the judicial branch through this Supreme Court has superintendent controls over the courts of this state. So the appellant's interpretation has effectively said that the legislature has the authority to determine who may or may not come into a courtroom with a handgun, regardless of the permission of the presiding judge in that instance. And so that creates a conflict with the Arkansas Constitution, because then that would be reading the statute to say that the legislative branch has the authority to control conditions and circumstances in which people may enter into a courtroom, regardless of the presiding judge's wishes in that situation. The appellants have also acknowledged in their brief, and we agree, that the bringing of firearms into a courtroom is a matter of security. And so it also raises the question of who has control over court security of the courts in this state. Is that a function of the legislative branch or the judicial branch? And again, we point to the separation of powers and Amendment 80 to the Constitution, which gives superintendent control of the courts to the judicial branch. We also have looked at the Arkansas Court Security Act. That is a statute that creates positions and enforcement positions that then gives off the function of court security to the judicial branch. And it is between the judicial branch and the local municipalities or counties that own the court buildings to come up with court security plans. And so that kind of gets to one of the questions that the appellant has raised as far as, why do we have standing? Why are we here today? Well, under the Pulaski County Court Security Plan, which is created in conjunction with the county officials, in this case, Judge Hyde, and the administrative judge. And I think there's been some confusion in Pulaski County. The administrative judge is one of the circuit court judges who has been appointed by the rest of the circuit court judges to act as the administrator or make administrative decisions And so it was that circuit court judge who worked on the court security plan to establish the court security rules for the Pulaski County District Court and Circuit Court. So that is one of the reasons that we have standing here, is because the county judge, being the executive over county property, is required under the statute and is required under the county's obligation to provide for the administration of justice adequate facilities for courts, and that includes security and established security procedures.
Counsel, let me stop you and go back to your interpretation of the statute. We have a list, and then we have that language at the end of the list that says, or other person authorized by the court, but you're arguing that that other person authorized by the court goes back and modifies everyone on the list, the authorized by the court language. And so if that's the case, why do we need 1, 2, and 3? If number 4 is there and has a catch-all, doesn't that render 1, 2, and 3 superfluous language that's just not necessary?
I don't believe so. I believe that it is the legislative branch's guidance that it's trying to provide to the judicial branch as far as examples. I read it in a similar manner as to a list by the legislature in a statute that says this entity has the powers to, but not limited to, or this entity may do these things, but is not limited to these things, which there are several examples of statutes.
But that raises a point. The legislature does that frequently, but they didn't do that here. They didn't say A, B, C, but not limited to, or except for. They said A, B, C, and then you want to say that authorized by the court language essentially wipes out A, B, and C. And so, I mean, the legislature could have put limiting language, they could have put expansive language, and they did do some expansive language, but it was only to that last portion. So 4 items on the list, 1, 2, 3, and then 4 also carried that language that had that expansive language with as authorized by the court. It seems to me that it really takes a strained reading to say that 1, 2, and 3 are there, but they don't really mean anything. I mean, the way you're trying to interpret it.
Well, I would just say that I believe in any of the lists provided by the legislature where it says this entity has the power but is not limited to, and then provides a list of things. I don't think the list provided in those other statutes renders the items listed therein as meaningless or as superfluous there. I think it is just giving items or examples of things that it considers would fall into that category. But then by using that language, but not limited to, it is providing that there's greater expansion, and in those cases, within the discretion of that determining entity.
So if instead of an officer of the court in his role as an attorney, if Mr. Corbitt was a certified police officer and had walked into the courthouse, could they have also prevented him from coming in carrying a firearm in that situation?
Well, the court would have looked at what is controlled by the court security plan, which is the controlling document.
I'm looking at the statute. Under the statute, could they have stopped a deputy, a state trooper, or a city police officer from coming into the courthouse carrying a firearm?
Pursuant to the authority of the court under the Constitution, yes. It is the judge, the judicial officer.
Can you point me to which section of the Constitution allows them to control the courtroom or the courthouse in such a way that a law enforcement officer could not walk in with a firearm?
Well, I believe that goes to the powers, the superintendent control of the judicial branch, the judiciary over the courts.
So let me look at that. Section 4 of Amendment 80, superintending control. The Supreme Court shall exercise superintending control over all the courts and may temporarily assign judges with their consent to courts or divisions other than that for which they were elected or appointed. These functions shall be administered by the Chief Justice. I'm not sure where in that power to regulate the operations of the court, including the assignment of judges, we get the county's ability, and it says specifically in that second sentence that this is a function of the Chief Justice. So how does the county judge or the county committee that came up with a plan all of a sudden carry the right of the Supreme Court or the Chief Justice to administer operations and appoint judges temporarily.
So the court security plan was created in conjunction with one of the circuit court judges who has that authority through the judicial branch to control the courtrooms of the courthouse. And so he was given the authority on behalf of the other circuit judges to make that determination as to their determination for court security and make that determination on firearms in the courtrooms. And so in the case of Pulaski County, the circuit judges came to the determination in conjunction with the county for the court security plan that firearms are prohibited. And so it also comes to the implied powers.
To be clear, your argument was that this fell under the superintending control that the judicial branch had. And that superintending control was a power of the Supreme Court, not of the circuit judges.
Yes, Your Honor. But the courts themselves have the inherent authority to conduct the conduct within the courts to ensure that the courts themselves are conducted in a manner in which the judge presiding over that court deems appropriate. And so the courts have the inherent authority to determine who may or may not enter a court if the judge deems that to be inappropriate and determines the circumstances around the control of his or her courtroom. That is part of the inherent authority of judges within the judicial branch, and pursuant to the separation of powers doctrine, that courts have that control over their own courtrooms. I believe that is further enhanced by the language regarding the superintendent control over the judicial branch, but it is also just an inherent authority of the judges in their courts to control the conduct within their courtrooms.
Well, and I understand controlling the conduct within the courtroom, but to your point that you just made, that judges have the authority to control who is in their courtroom, I agree to some extent, but that also has limitations. I mean, the defendant has the right to be present during trial. The judge can't really say, no, you got to leave, unless there's some behavioral issue in which they can take a break. You know, there are some scenarios I suppose you could paint. We have the right to a public trial. So the public has the right to be there, again, assuming they're not causing disruption and doing things of that nature. I mean, there may be some exceptions, but it's not an absolute right.
Well, these rights that we're talking about all stem from the Constitution itself. And that's where we are trying to found and stay within, is what the Constitution itself says. And
okay,
so, yes.
You said that you were looking at the Constitution for the superintending control, but I think that doesn't really apply here. The other area you cited of the Constitution is Amendment 80, Section 3, which gives the Supreme Court the power to prescribe rules of pleading practice and procedure for all courts. But I think the part that kind of got left out of that argument is, provided that these rules shall not abridge, enlarge, or modify any substantive rights, and shall preserve the right of trial by juries declared by the Constitution. And so isn't the right that we're talking about here a substantive right? The right to possess a firearm, the statutory right to carry that firearm in certain places, aren't those substantive rights that are outside of the scope of the power in Section 3 of Amendment 80?
As far as the substantive rights created in that circumstance, again, I believe that it is the right of the judges through the separation of powers and the inherent authority of judges to control the conduct within their court to make that determination. And there are instances where judges may have to abridge rights in the instance of, say, contempt. Like you point out, an individual has a right to be present for his or her trial, but if that person becomes a disruption, if that person causes an issue, and so it is the determination of the judge to determine what is appropriate within his or her courtroom. And so that is what gives judges the authority to make that determination for each individual court and within the judicial branch to ensure that the court proceedings themselves are appropriate.
But in this case, we never got into a court proceeding, as I understand. This was a stop at the door, and I'm not aware of any allegation of disruptive behavior or inappropriate use or brandishing of a firearm. Based on the facts that were presented in the record here, I don't think any of that is present. So
it's because the appellant never had authority from a court to enter into a courtroom with a firearm pursuant to this statute. And so that modifier there is what establishes that each individual, each one of those categories is required. Everyone that falls within that category is required. Otherwise, looking at the term officer of the court, as has been noted, it's not defined anywhere in the statute. Originally, the appellant was looking into the comment section of the rules of professional conduct to say that attorneys are officers of the court. But the Supreme Court of the United States has acknowledged that attorneys generally are officers of the court. Other statutes from other states have acknowledged that court reporters, process servers, expert witnesses are officers of the court. So under this broad interpretation, that would be that any attorney from anywhere in the United States or any process server from anywhere gets to come into any Arkansas courtroom with a handgun, with or without the permission of the presiding judge. It's such a broad category of individuals that it becomes unenforceable. Though attorneys may be regulated, attorneys are not the only people that fall within the category of officer of the court. Under this broad definition, essentially anyone from any law, comment, case that has ever been titled as an officer of the court could come into any Arkansas courtroom with a handgun with or without the permission of the presiding judge. So that overly expansive language is what also complicates and demonstrates that what limits it is if that person has authorization from the court. Then it goes from being this super expansive list of anybody to that individual that has authorization from the court. And that is what makes
Counsel, why did they amend the statute in 2019 to delete the word any? Because I believe, explain what that was, how that affects your interpretation.
Your Honor, I do not have a reasonable response for that, and I apologize.
Counsel, let me ask you to follow up on a question that Justice Hudson asked of counsel for the appellant earlier about the requirement of entitlement to a writ of mandamus being the establishment of a clear and certain right to the relief sought. Here there was a claim for declaratory relief and also the petition for the writ of mandamus, which were both denied by the circuit court. So could you address that, please?
Well, so the appellant initially sought for declaratory judgment and injunctive relief. So he sought multiple routes, and each of those would have provided him the relief that he was seeking to be allowed to enter into the courtroom with a handgun. After the case had proceeded after some time, he then also filed his petition for writ of mandamus. In his appeal, the only question that he asked this court is for it to review the denial of his petition for writ of mandamus. Though I acknowledge, I know that Professor Steinbuch sought to amend his brief, we were never provided a copy of the amended brief itself. I believe it was rejected. He filed it, I'm assuming, but it was never sent because it was rejected. So we never had an opportunity to see what substantive or if it was just ministerial or just pagination changes that were in it. So we didn't have an opportunity, but we've looked at and we've responded that the question that the appellant is asked is whether the circuit court was correct in denying his petition for writ of mandamus. And in that case, we're looking at an abuse of discretion standard to see whether he was entitled to a clear and certain right, and that was the only remedy available to him, which in this circumstance, he wasn't entitled to a clear and certain right. As was pointed out, if he's having to ask for declaratory judgment to establish if he has a right in the first place, it inherently can't be a clear and certain right. And by asking for multiple forms of relief, as well as still having the opportunity to appeal, he had multiple other forms of relief available to him. So a petition for writ of mandamus was inappropriate. So I just want to point out that the other reason that we do have standing here is the appellants, the parties themselves, are elected officers created through the Constitution. Under the Constitution, elected officials are required to take an oath to uphold the Constitution itself. So in this instance, when we were presented with a petition or with a complaint seeking for us to enforce an unconstitutional, as we interpreted, unconstitutional position, we believe that Judge Hyde and Judge Higgins or Sheriff Higgins had a obligation to uphold the Constitution. And so that obligation to uphold the Constitution itself gives a basis for challenging an unconstitutional provision, in this case, a violation of the separation of powers doctrine.
Okay, counsel, your time has expired. Are there any other questions? If not, thank you.
Thank
And
you.
the court permit rebuttal for the appellant.
Thank you, Your Honor. With your permission, just to look at the statute one more time, because appellees have, I'm not sure you can read it given the sunlight. I apologize. In any event, we'll go with the text. Appellees stated that it says of any courtroom of a courthouse. It does not. That's just a misstatement, and that happens. But the statute was amended to add or a courthouse. These are separate categories. It says a handgun in the courtroom of any court or a courthouse. So those are separate. And my client is entitled to bring his gun into the courthouse. And that's the only issue that we're raising. Finally, the appellees referred to these statutes from other states about, oh, there are other definitions of officers of the court. That doesn't matter here. The question is what officer of the court means in Arkansas. It either entirely or largely means attorneys. I haven't, I don't want to preclude that there's a statute out there that may cover something else, but it's not a broad category. And then he also says, the appellees also say that, oh, well, any lawyer from anywhere could come in. No, officer of the court, this court. It's only people admitted in this court. That's all I have, unless you have any questions, of course.
Counsel, I have a question.
Yes, ma'am.
So regarding your declaratory judgment and the relief seeking, it's a declaratory judgment. You're asking for a reversal, but in regards to a declaration that the officers of the court, attorneys are officers of the court and allowed to enter courthouse buildings. But you're saying, but not courtrooms. You're not asking for a declaration regarding courtrooms, that part of the statute. That's
which is not, that's correct. We're just not addressing, we're not asking for that here. That's correct.
Okay.
Any other questions? Okay, if not, thank you, counselors. So that will conclude our oral argument in this case. Justices, we will recess for 15 minutes and then log on to our Zoom conference for our case conference. First in the case where we have a special justice, and then following that, this case and the other cases. So at this point, court will be adjourned. Thank you.
Thank you.
Thank you, Justices.